That works. I could have this so crazy. But the lights aren't on.
No, I know.
Oh, hold it. What? Did that help?
No.
Okay. Did you break it? Okay, no, don't start crying. Everybody just relax. Ellen, I don't feel safe. All right, thanks. Really? Whole thing?
Yeah,
I gotta step off. I'm just staying out here. Fine. No, I'm leaving. All right, court is standing in recess. Everybody can remain seated.
I could participate in here.
Though, because it seems to change quite often. So he's entitled to leeway. He's losing his patience because he's asking, but he is saying different, he's giving different testimony.
Judge, I'll say this. I understand your point, and certainly the timing of when things were thrown away has been, a little bit back and forth. But the specific question about whether there's any property in the house at the time of stabbing, he answered that question no specifically just a moment ago.
Yeah.
And he asked it again. So that's why I didn't object to the other questions because of what you're saying. But that particular question is why I'm objecting.
I don't know if it even means anything.
I agree with you, Judge.
But he has said he threw things away before, he threw things away after. I think Mr. Ingle's trying to establish that they were there in a place where they had lived to pick up the remainder of their items.
Mm-hmm.
So I'm giving him some leeway. I think we beat it to death, but I could be wrong.
Let's talk about the dog. You said the dog was transferred. How did that happen?
My wife called the shelter where it was from, and we talked to the person that runs the shelter, and they had everything transferred.
Okay, did Tia or Wilson ever agree to transfer the dog?
Tia and Wilson had abandoned the dog, so that's the shelter had.
You say abandoned. Again, how long had it been since they'd been there?
Weeks.
Okay. And so your view is if you just call up the shelter and say, hey, transfer the dog, that's all that needs to happen then, right?
We called the shelter. We told them they abandoned the dog. The dog had been there for weeks. They transferred the dog into Caitlyn's name. That's it. That's all that happened.
Okay. Do you have any paperwork for that?
I can get it.
Do you have any with you today?
Didn't know I would need it.
What?
Didn't know I would need it.
Okay, it's a yes or no question.
I didn't know I would need it, but I do have paperwork.
So we're at the point, this person comes to the house and asks for their stuff, and what exactly do you say to the person who came to the house?
I told her that I threw the stuff away.
Okay, and what happened, and what did they say in response?
They started screaming and cussing and walked off, and I shut the window back.
Okay, so they just came to a window, a back door?
They came to the front door, and I went upstairs and I opened the window up and I looked down over top her head to talk to her.
Okay, and so so the next thing that happens is Tia and Wilson come to the house?
About 25, 30 minutes later, they came through my back door, yeah.
Okay, did they knock on the front door or anything like that?
No.
So your testimony is they just walked in the back door?
Yeah.
And where was the dog when this was happening?
The dog was running loose in the house.
And so what happened when they came into the back door?
They came in through the back door. Words was exchanged. Wilson had the knife in his hand. Tia started to get in the middle of us, and right at that time is when Wilson swung and the knife caught me in my head. And then my eyes was full of blood, and that's when I started screaming for Caitlyn's help. And then everything was all hectic after that. I don't remember much.
Okay, well, let me get where everyone's standing, right? So they come into the back door, right? Where are you
Yeah.
standing in relation to them?
I'm sorry, say it again.
Where are you standing in relation to them right as they came in the back door?
As they came in the back door, I was standing. This is my door. This is my living room. I would have been standing right here, like
So how close were you to them?
to the door.
Yeah.
How close was I to the door when they came through it?
Yeah.
I don't know. I was on the other side of the room almost.
Okay, so what were you doing when they came through the back
I
door?
was putting my shoes on
Why were you putting your shoes on?
because me and my wife had just decided we would get up and go to the store.
Okay, so you're putting your shoes on. Where are you putting your shoes on?
I was sitting on the edge of my bed in the living room.
And you see them come through the back door.
Yeah.
Okay, so what did you do? The first thing you did when you saw them come through the back door?
First thing I did was jumped on my feet and said, "What the fuck are you doing?"
Okay, and how did they respond?
Tia started screaming something. I don't know what the hell she was saying. Wilson started screaming about the dog, and about that time is when he swung with the knife and cut my head, and my eyes was full of blood. And yeah,
Okay, so what other
Oh, I
word?
remember.
What else did you say to them as you're standing there exchanging words?
tell him to get out of my house.
Did you threaten them at all?
No, I told them to get out of my house.
What did they say?
They didn't say anything. I think one of them screamed "fuck you" or something, and about that time is when he cut me, and everything, all hell broke loose.
So I guess I'm trying to figure out why did he, if they're coming to get their dog and their baby.
Because that's not what they was come to do, sir. They come to stab me. They come to attack me in my home, and that's what they done.
Okay, how do you know that?
Because that's what they did. That's how I know. Because that's what they did, sir.
How do you know that they weren't coming into the house to get their stuff?
Because they would, if they was coming to be cordial and to be nice to get their things, can I have my stuff, please? No. Instead, they came through my back door and stabbed me in my head. Okay.
Well, someone else had come just a half hour before, you said, to try to get the stuff and was cordial and asked for it, and you didn't give it to them.
It's because there was nothing to give them, and I told you that.
So at some point during the altercation, you get stabbed, it looks like, right?
Yeah.
Okay, and that's the, oh, that's hard to see. That better? That's better. So that's all blood there. Now, that's because you had a wound in your head, right?
I swear I got stabbed. Yeah.
Okay, you didn't have any other wounds anywhere else?
Mm-mm.
Okay, nothing on your hands?
I don't think so. No.
Okay, nothing on your arms?
I think yeah, I only had some bruises on the back of my arms, but other than that, no, I don't.
No, no cuts.
Just my head, I think.
So the only place, so he's swinging this knife wildly, and the only place he got you was on top of the head, right?
Yeah.
Yeah. And it bled a lot because it's a head wound, right?
Mm-hmm.
Right. You didn't have any. I see blood on your face, but you didn't have any cuts on your face or anything like that, right?
Right.
And now nothing about this picture tells us whether this was a defensive wound or let me back up. You understand that T and Wilson say that you threatened them and they were acting in self-defense, right?
Yeah, I understand that.
Okay. Nothing in this picture helps us answer that question, right?
Well, I mean, I did get stabbed in the top of the head. It kind of looks like a defensive wound to me.
Okay, but nothing tells you whether if they say you swung at them first, for example, nothing in this picture tells us anything about that, right?
Say that again.
This is just what happened after the event, right?
What, yeah, that was them taking a picture of my head after the fact.
Okay. That's exhibit 2A. The same with exhibit 2B here, right? That's a picture that was taken after the fact, right?
Yeah. Yeah, that's the half-inch gash in my head.
Nothing in this picture tells us, for example, who started the fight, right?
Well, I mean, they come through my back door and stab me in the head. They started it. It's kind of.
I understand. I understand that's what you're telling us, but
The
nothing in
evidence
that,
is kind of, just, I guess you gotta, I don't know.
so nothing in that picture tells us anything about them coming through the back door, for example, right? This is just after the fact.
The picture, yeah,
Okay.
sure.
And exhibit 2D, that's your back door. That was taken after the fact too, right?
Yeah. Yep.
Who took that picture?
One of the cops.
The same with exhibit 2E, that's after the fact too, right?
Yeah, I would assume so, yeah. Yeah, that's after the fact.
Same with exhibit 2F, right?
Uh-huh.
Judge, the state will stipulate that all the pictures of the crime scene injuries did not occur before the crime occurred or during the crime.
Okay,
We don't, I mean, that, you said that's your blood, right? You're not aware of any tests that were done on that blood, right?
What?
Was that test, was there any like DNA test done on that blood or anything like that?
Something you'd have to ask the police department.
Okay, you don't know if it was done, right? As you
No,
sit
I
here
do
today.
not know.
There wasn't any damage done to your door, was there?
No,
Any damage done to any other property in your house?
no.
One moment, Your Honor.
yes.
I have nothing else. Thank you, sir.
All right, thank you.
Wait 1 second, Judge.
Yes.
Mr. Edsel, you can't step down, sir.
Do you have any redirect?
I mean, I didn't know if Mr.
Mr. McKenna?
Judge, everything I would have asked, I would have asked about.
Okay. Any redirect?
Yes, Judge, thank you. Mr. Edsel, first of all, you're asked about whether or not the blood on the ground and all the blood we saw was yours. To your knowledge now, just if you know, did you see anyone else bleeding before or after that incident?
No.
Okay. Sir, you were asked about threats. Did you make any threats to either one of these defendants that day?
No, sir.
Did Caitlyn make any threats in your presence towards any of these individuals?
No.
When you were in the home and they came in, did you ever have a weapon?
No.
To your knowledge, did Caitlyn ever have a weapon?
No.
Did you ever in any way attempt to use any force against either one of them before you were cut?
No.
Did you see Caitlyn do that?
No.
Now, sir, do you recall whether or not, in addition to the injury on your head, do you recall whether or not there was an injury to your shoulder?
My shoulder? No, I don't think so.
You don't remember whether that's true or not?
No.
Judge, we don't need to approach as a bench trial. The pictures you've seen so far, Judge, are things I disclosed a long time ago to the defense. Also, in addition to that, there are body cams that I disclosed to the defense. And in the body cam, actually, one of the officers who's there with Mr. Etzel at the hospital mentioned seeing an injury to his shoulder. I was just asking the detective about the fact that I never received a photograph of any injury to his shoulder as he's testifying. And she actually has with her a photograph of an injury to his shoulder. So I have not disclosed the photograph. However, as I said, the body cam that's been disclosed to the defense clearly shows the exact same thing. So there would not be any surprise about the fact that there was an injury to his shoulder. So I think the defense would object, but at this point I would like to it would be State's Exhibit 2I.
Did you just establish that he would be surprised if there was an injury to the shoulder?
No, I'm saying that defense counsel would not be, this is not some surprise to them that this would exist because it's on body cam.
But he just denied having an injury.
He said he didn't know whether, I thought he said he didn't remember whether.
Okay.
Cool.
I'm sorry, I thought he said he didn't remember.
All right. Any objection?
I do object, Your Honor, to a photograph that wasn't disclosed in discovery. I mean, our clients, two problems. One, my cross-examination might have been different if I had known about a photograph like this. Actually, three things. Two, I think, as Your Honor noted, he did already say he could testify about injuries. He testified he didn't remember there's an injury. I think they're stuck with that. Third is if we're going to relax the disclosure rule, our clients brought in some additional exhibits this morning that we didn't think we could use because they weren't disclosed. But if we're going to all of a sudden open up the door to exhibits that people are bringing in the morning at trial, I think there's an old legal doctrine called sauce for the goose, sauce for the gander that would apply.
Okay. I'm not going to permit the photo, but I will permit the body cam footage that shows the same thing. There are rules that we have to follow.
You want to go through all the body cam or are you just going to do this? I don't care. I'll just take half an hour and get one again.
Just show the part of the body.
Well, I don't have to go through it again. I mean, I'll have to take a break. I don't care. That's fine.
None of this came up on
What's that?
direct.
What's that, Judge?
None of this came up on direct.
Well, I asked him about his injuries on direct, and there was more questioning about that on cross-examination, about were there any defensive wounds, were there any other wounds, which is what got me thinking about having watched the body cam and seeing that discussion and realizing, I mean, I knew I didn't have the photograph, but the additional questions on cross-examination about that caused me to ask the detective about the photograph. But Judge, for whatever reason, and part of this is Middletown, I think you know, part of the reason why this case got annihilated and re-indicted, Middletown had their entire system hacked and they couldn't access information for a long time. So a lot of information is coming slowly over time. For example, the 911 call I just got just a few days ago because of that. So that's part of the issue here is over time they didn't have everything to give to me because of that. But that's what brought that issue up.
I would just suggest, Your Honor, I mean, he could testify about his own injuries. That's the best evidence. We should just let him do that and move on. I mean, especially, I think if you're now going to show a body cam, if he said, I don't have or I don't remember injuries, he's now impeaching his own. I mean, he could show the body cam maybe for
rehabilitating him.
but he's impeaching his own witness. I mean,
I'm sorry to interrupt you. He's rehabilitating him. So the ruling is the same.
Right.
He can ask him, he can show him the body cam. If that refreshes his recollection, then you'll have a chance to cross-examine. It's borderline whether or not it's admissible simply because he's starting his case again after you've cross-examined. But I'm going to go ahead and permit it.
If I may have, I'm sorry to interrupt you, but the Solomon-like solution maybe, which is, I think he could use the photograph to refresh his recollection without admitting it into evidence. And I think we'd probably be okay with that. If his testimony changes as a result of refreshing his recollection of the photograph, we're okay with that.
Okay, that's fine.
That
And
makes
Judge,
sense.
also, I would just say, I mean, if I show a body cam to a police officer who's a different witness, that wouldn't affect his cross-examination. It's evidence they've had for a long time.
Okay,
But I'll show you this. Just take a look at it. So you've had a chance to see another photograph, is that right?
Yeah.
Was that a photograph of you?
Yeah.
And does that help you remember whether or not you had an injury on your shoulder?
I remember the bruise being there, but as far as any pain, I wasn't in no pain in my shoulder. That's why I didn't recall it the first time, I guess.
Okay. So, sir, you're talking earlier about, I was asking questions about actions that you and Caitlyn did or did not take against these two when they entered your apartment. Was there ever anything that you did in any way to provoke Mr. Rivera to then use this knife against you?
No. As soon as I seen them, I asked them to leave. I told them to get out of my house.
And to your knowledge, from what you saw, did Caitlyn, your wife, did she do anything that was provocative or would have provoked him to injure you in that way?
No.
Okay. All right, Judge, I have no further questions.
okay, recross. Mr. Engel,
Nothing.
Mr. McKenna.
Nothing, Judge, thank you.
Okay, sir, you can step down. Next witness.
State Hall, Caitlyn Hall, Your Honor.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Hey, man, you're fine.
Sorry.
You're fine. Now, you got a kind of soft voice, so make sure you keep your voice up for us, okay?
Okay.
All right, tell us what your name is, please.
Caitlyn Hall.
All right, how do you spell your first name?
Katelyn.
And do you know Jesse Zel, the man that just testified?
Yes,
And how do you know him?
he's my husband.
And were you married on August the 1st of 2025?
Yes,
And in the months beforehand?
yes.
Now,
Can you spell your last name?
Hall, Hall.
Okay, thank you.
Sorry.
Go ahead, I'm sorry.
no, you're fine, Jess, thanks. So on August the 1st, and let's say the 3 or 4 months before August the 1st, where were you living at 2025?
At 6880 Brandywine Street. We had just moved there. We'd only been there for like a few months or whatever.
Okay, but were you living at that Brandywine address prior to the time that Tia and Wilson came to live with you?
No. First, we had a different apartment when I first met them because I lived a little bit closer to Raleigh's actually. So I moved into a Section 8 home after that. But when I first met them and everything, we just talked at work and stuff. And from there, I heard Tia on the phone one day and she was crying. And I asked her what was wrong. I got into it because she was pregnant and it was just, I wanted to know. She said that she had been sleeping outside and that her mom would not let her inside the home. And that Wilson as well was sleeping outside with her, and they were sleeping outside on a park with it raining and on a slide or whatever. So I felt bad, and I instantly called my husband. I said, look, there's this pregnant girl. She's sleeping outside in the rain. Can we please help her? He had no problem with that instantly. They stayed there for only a couple days on my couch. They did really well there. All of a sudden one day.
Let me stop you real quick, okay? I just want to ask you as we go along. So when they came to stay with you, it was at that Brandywine address that you've given us?
No, it was the North Verity one first.
Okay. And then you moved and they came with you?
No.
Okay, tell us what happened.
So when they stayed with us on North Verity, that was just for like a few days on the couch. I woke up one day, they had disappeared and sent me a text telling me, thank you for letting me stay. You know, we figured it out. We're just going to go somewhere else. And so that was fine. I no longer heard from them because I went to work and heard that Tia didn't show up for work, so they fired her. So it went on for a couple weeks like that. And then we had moved into the Brandywine address, lived there for a few months. We're getting our stuff together. And I got a text randomly one day from Tia, and she was in the same situation yet again. And she knew we helped her the first time and asked if we would help again. And I said, of course. I said, if you meet me at my job tonight, I will help you and I'll take you back to my place. I'll get you guys some food because I know you're hungry, and I'll make sure that you have a place to sleep for a couple days.
Okay. So I think you mentioned this before, but when on North Verity, when they stayed with you, were there ever any problems between yourself and Jesse and Tia and Wilson?
No, at that time, they were really thankful. They were really nice at that point.
Okay. And then, so now you're on Brandywine. You're staying in this apartment again, and they're staying with you. How long did, when you were at Brandywine and they came to stay with you, how long was that?
We had been at Brandywine for about 6 months or so, I'd say.
And then how long did they stay?
They came down, they stayed for a couple weeks. They went back and forth between my house, Wilson's house, and Tia's mom's house because they told me that Tia's mom had roaches and bed bugs in her house. They told me that Wilson's family was as well on drugs, and that there was also a possibility that Wilson's dad was the baby's father, so they didn't like to be around his dad. Understandable at that time. I thought it was weird, but I didn't judge it, and I just moved on.
So in this couple of weeks they were staying with you at Brandywine, they would stay with you, but then they'd also stay at a couple of other places.
Yeah,
they
they would-
rotate
Yeah,
where they were staying.
her mom would guilt trip her and make her come back. So she'd go back over there. Her mom would start doing drugs there, having people in and out of the home, and she would have to leave because she was pregnant and didn't want it around her or the baby, which was completely understandable.
Okay. So this Brandywine address that you're talking about, that's in Middletown, Warren County, Ohio.
Yes.
And the two people you're speaking of, Wilson Rivera and Tia Spradlin. First, can you tell me where is Wilson Rivera seated, and what's he wearing?
Right there next to his attorney. He's wearing a white button-up shirt and a black tie.
All right. Where's Tia and what's she wearing?
Over here next to her attorney, wearing a black little pullover shirt and a white t-shirt or whatever.
All right, Your Honor. Ask her to reflect that she identified both defendants.
Yes,
Stipulate.
they've already stipulated this.
So these are the two individuals you're speaking of that came to stay with you over this couple-week period of time.
Yeah.
So what property, if any, did they initially bring to the Brandywine apartment?
They brought a backpack of a few things. They didn't even have anything for the baby at the time. I couldn't even get them to go to work. They wouldn't work. They wouldn't do anything. All they wanted to do was fight about who was where with each other. They couldn't leave each other, so they couldn't work, so they didn't have no way to provide for this baby. I had so much baby stuff. My son was a year old, so I had all this baby stuff. I had a pack and play, a car seat that they actually still have the baby in right now. I had a bassinet that they were putting the baby in. I had all kinds of clothes. I had diapers for days and all kinds of sizes, from the newborn all the way to size 6. And I told them that while they were there, they could use my stuff for their baby, but it cannot leave my home because if they have roaches and bed bugs at her mom's, I don't want it transferred there and back into my home.
Okay. So you were, fair to say, you're doing what you could to help both of them.
Yes, I felt bad. I've been pregnant and homeless too, so I felt so bad, and I felt like, somebody helped me at that time. I could give back and help somebody else.
Now, at some point after this couple of weeks where they're staying with you on and off, did they just stop living with you?
It didn't just stop. What happened was Wilson asked if his sister could come over. I said yes, because she wanted to see the baby. The baby was already born at that time. She had came over, they went upstairs, they all came down, said that they were going to his mom's house. I guess from there, Tia must have got drunk at his mom's house, and they went over to her mom's house, and they started fighting with the
Hang on 1
baby.
second. When one of them, if they say eject, you have to stop for a second, okay?
You're objecting because she said, I guess.
Yeah.
I can just give it the proper weight, so overrule.
Anyways, They had went to his mom's house to visit with the baby, whatever. I guess Tia ended up drinking over there. Somehow they went from there to her mom's house. I ended up getting a call from Tia. She was crying, freaking out, saying that the police were already at her mom's house, that Wilson tried to steal the baby from her, was trying to rip it out the car seat away from her. It was a big old thing. And she said that Wilson had took off, that the police let her keep the baby at her mom's house, and she asked if Wilson was at my house. I said, no, Wilson's not here. I told her that if he would come there, that I would tell him he cannot be here because she's not there either. So I don't want the mess going on at my house right now. I went down that night to Tia's to drop off baby formula, diapers, just the essentials that she would need because I knew she wasn't planning to stay there that night, I don't think. And so I just wanted to drop off some stuff that the baby could use and he would need. And from there,
At this point, Your Honor, I think we're dealing with a story that's very old and has nothing to do with the events of this day. And I think there's a lot of speculation in it.
In response.
Well, I mean, it definitely has something to do with what happened this day, because she's talking about the time period between them ending living there and then this event occurred. But I can certainly ask more specific questions if the court would like for me to.
Most of what she said was hearsay, but she did try to explain what she was thinking, what her state of mind was at the time, which I can consider. The hearsay, I'll ignore. It doesn't matter. It's irrelevant. So move on.
All right, thank you, Judge. So after the 2 weeks you talked about that they were staying on and off with you, did they stay with you again before this incident happened or not?
no, I told them they could not come back after they got into a fight with the baby and the baby was being yanked around in the front yard with her mom. I
Okay.
told them I can't have that at my house.
So the story you were just describing to the court was your reason why they were not permitted to come back.
Yes. The other reason is I had children in foster care at that point in time. So obviously I'm fighting like hell to get my kids back home with me. I could not have somebody that was fighting over a baby somewhere coming to my house. And if they would have gotten into a brawl over that baby would have got hurt. I'd have lost complete custody of my children.
Okay. So then I want to fast forward to August the 1st of 2025, okay? If you can remember, about how long was it between the last time you saw Wilson and Tia until August the 1st, 2025?
It had been a few weeks. Tia texted me a few days after they had left. She was crying around saying that Wilson hadn't came back yet, that her and the baby missed him. And then all of a sudden he showed up one day, I guess, back at her mom's house. And that's when they wanted to text and ask if they can come back over because all of a sudden, one day you're not, I can't have this continuously going on. I mean, I heard her call him an effing N-word one
Well,
day.
hang on. So do me a favor. I understand that this is kind of an emotional thing and you're talking about different events that took place, but what I need you to just listen to my question and answer what I'm asking you, okay? So the question I have is, if you remember, just the time period between the last time you saw these two and the time that this incident happened on August 1st.
It had been a few weeks.
A few weeks, okay. So August the 1st of 2025, were you home with Jesse?
Early in the morning, we were home. So I got up at 6 a.m. because I had stuff I had to go do that day. At the same time, I had seen that Tia sent a message. She had asked if she could come over. I said no. I told her that if she gave me some time when I got home, that we would figure something out and I would, try to work something out with her to figure out whatever it was she wanted. But that I was busy that morning and I had things to do and I didn't have time to talk right now.
Right, so after they had left and this few weeks had gone by, was there still property of theirs at your house?
There were a few little items that closed. All the baby stuff was still there, but all that baby stuff, like I said, was mine and my son's and something I still planned to use when he came back home.
Mm-hmm. And then what about the dog?
The dog was still there.
Okay, so tell the court if you would, how was this dog initially obtained and then why was it in your possession on August 1st, 2025?
So I had a giant white pit bull and Wilson really liked my pit bull. I told him that I would not care if they got some kind of animal, but that they would have to be on strict rules with this dog. So the dog could not come and go. It couldn't be around all kinds of craziness. They have to clean up after it. And then the dog starts eating its own feces.
Well, wait a second. So you told them you were okay with them getting a dog. And then how was this dog obtained?
I drove them to the shelter. They picked out one dog, but they were told they could not take it. So we left. They called us back because they were wanting the Sophie first, but Sophie was possibly pregnant, so she couldn't leave the shelter at that point in time. They had to do an ultrasound. They had to make sure this dog wasn't pregnant before they just give her out, which is understandable. So we left, and it was a couple weeks later. I get a phone call. Tia's already at her mom's house at this time, and the shelter's like, hey, this dog's available for Tia. Do you know how to get a hold of her? I said, I don't have a number, but I can go tell her. And so that's what I did. I went and found her at her mom's house. I said, hey, dog's still available. Did you guys still want it? She said, yeah. I said, well, come on. I will take you to go get it. And I took her up there to go get it. It was a foster to adopt. So you couldn't actually legally adopt the dog fully until the dog was spayed. So they had to get a date to spay the dog, but they were all booked up. So until they could get a booking for the dog to be spayed, it was on a temporary foster agreement to where they could not permanently adopt right away.
Okay, so when they left your house, did they leave the dog behind?
Yes.
And was the dog still in this temporary status when they left it behind?
Yes.
Okay. So then, did you have any contact, other than what you mentioned just a moment ago, on August the 1st of 2025, during that day, before they came into your home, did you have any other contact with either Wilson or Tia?
Now I was trying to look for work. I was busy trying to prepare my life to get my stuff together. I had a case I was working on with, my CPS lady. My mind was other places than worrying about what they were doing.
Okay. So were you home that evening around 8:30 or 9?
Yeah, we had just got home. We had left, went to his uncle's that day, and of course our car broke down. Completely broke down right in the parking lot. So we had to wait forever. We had all 4 of the dogs. We thought about just staying the night. At the time, that probably would have been our best bet. If we would have stayed the night, they wouldn't have came in like they did. Probably couldn't have. Maybe they might have been able to. Hopefully my mom wouldn't have ended up hurt, but she was there
Could you
that
stay
night.
on point? He's really asking you some pretty direct questions. I know you're giving a lot of history here. It really doesn't matter. So the question was, did they come back, correct?
Just, I just asked her if she was home around 8:30 or
Okay, were
9.
you home around
that
8:30
evening.
or 9 that evening?
Yes,
Okay, I'm not trying to
but I was
make it
asleep.
difficult for you. Okay.
Okay, and Jesse was home with you?
Yep.
Okay. So then, what's the first time you became aware that the 2 defendants were inside your home?
I heard a loud banging at my door. That's what first woke me up, was the loud banging. I went and reached for Jesse. I always do that first thing. I reached for him. He wasn't there. I was like, Jesse, where are you? Someone's at the door. And he was like, it's Tia and Wilson and whoever else brought them. And I was like, what do they want? And he was like, they're just screaming. They're screaming stuff to the neighbors. Everybody's outside screaming. He was like, I told them to leave. So I went into my bathroom and I looked out my little window, and it looked like they had all 3 got back into the car, and I could see the car driving down the street, and I thought, they're gone. It's over. It's fine. We're good. So we tried to lay back down for a minute, but I realized it's late. We just got our food stamps. So I was like, why don't we go to the store, get something to drink, get something to eat? I'm done wide awake now, so I can't go to sleep. We're getting ready and stuff, and all of a sudden I see this flickering light through my back window, and I'm like, what is that? And it looks like a flashlight. So I'm thinking it's the cops. They called the cops, which I'm like, okay, cool. So there's going to be a cop coming through my back door. There's about to be a cop at my front door. I'm just preparing, waiting. But then I hear my sliding door go whoosh, and I was like, what the fuck? And we're looking at each other, and before we get what the fuck out, because we're both saying it at the same time, you just see Tia and Wilson pop out behind my sheet. And I'm just like, what? Because I thought the cops were coming.
You saw the pictures earlier. You were in the room, right? You saw the picture earlier. You mentioned, is the sheet that we saw in the picture that was kind of almost like a curtain for the back door?
Yeah, we turned it into a curtain because with that big window, it just brings too much sunlight in and it makes it too hot in the living room.
So before you saw Wilson and Tia enter, was that back door, was that open or closed?
It was closed.
Okay. So they enter, and what happened when they came in?
when they came in, I kind of looked at them puzzled. I didn't get anything out of my mouth. Tia kind of looked at me puzzled for a second, and Jesse screamed, "What the hell?" Wilson kind of jumped around going, "Hee, ha, ha, what you gonna do now?" Whatever. Holding the knife in his hand, and when I first seen the knife, I couldn't breathe. I was like, oh God. And all of a sudden, I see Tia go in front of him, and then Wilson lunges. And when Wilson lunges, she flies forward. They're flying, him, and Jesse all fly into the bookshelf, which also hits my wall. And they busted a hole in the wall doing so. And that's when I crawled out from behind because I was also behind them. So I just got out, and I had my phone already on me because I was planning to leave. I always carry my phone. I ran into the kitchen. I dialed 911 as fast as I can because I know someone's getting hurt.
You ran into the kitchen.
I ran into the kitchen. First thing I do is I dial 911 because all I can think is someone's going to get hurt in this house, and I don't know who, and I want to deal with it right away.
Okay, well, let me stop you there, okay? So when Wilson and Tia came in your house, did you have any weapons?
No.
Okay, did Jesse have any weapons?
No.
When they came in, you mentioned, obviously, you reacted with surprise.
Yep.
And did Jesse do the same?
Yep.
Did either you or Jesse in any way threaten either one of them
No.
when this was going on?
No, it's not the type of person I am. I've never been in any trouble. I don't threaten people. I don't fight for no reason. I just try to help and do my own thing.
Okay. So then you mentioned you saw Wilson in possession of a knife, is that right?
Correct.
Do you remember, was it like a folding knife or was it like a kitchen knife, or do you remember?
It looks like a pocket knife of some sort. I could only see kind of the tip of it because he was holding it like this or whatever, how you hold a knife.
Okay.
And I could see it had a pretty decent sized, tip on it going up. And so I knew instantly what it was. And I knew when he had the knife, I knew they weren't there to talk. Because before they were always calm and cordial, but when he had that knife in his hand first thing, I knew it wasn't a conversation.
Okay. What's the basis?
I said objection non-responsive, Your Honor, she's not answering his questions. She's just going
Okay,
on.
I think she was answering his questions there, but you work at rallies?
No, not anymore.
Or you did at one time?
Mhm.
Did you ever take orders?
Yeah, I did.
What if someone were talking as fast as you do when they're placing an order? What would you do?
I pick it up and I keep going with it. I'm a fast person, so I take in
Okay.
information quickly. I bring it out quickly. I'm sorry.
My point is, I know you're nervous. Everybody is, not just you. But slow down a little, please. Okay. Go ahead.
So you mentioned that you saw Wilson standing with a knife, and I think you said Tia was between Wilson and Jesse.
No, at that point she was like beside, but then I think she knew what Wilson was going to do before Wilson really knew what he was about to do. And she kind of moved in trying to stop him, but it didn't work out for her.
Okay. So then did you actually see when Jesse was cut?
I did not, because I was in the kitchen dialing 911. I was trying to talk to them, and I heard him start screaming so loud, and I turned around instantly to look at him. And all I seen was him covered in blood everywhere, and he's screaming nonstop. And the only thing I can do is I'm reaching around. Everything is dark in my house, so I'm reaching around looking for something to try and help, and all I can find is this glass coffee pot, so I threw it. Just trying to cause a distraction, trying to do anything to keep him from getting hurt any more than what he already was. Because I seen his head was bleeding, but I didn't know if he was bleeding anywhere else I couldn't see.
So when you turn around, you see Jesse's bleeding, you're on the phone to the police, right?
Yep.
What were Tia and Wilson doing during that period of time?
I think Tia realized actually that I was on the phone with 911, and she looked at Wilson and goes, "Come on, she's calling the cops. It's time to run now." And they started going out the back door or something. I think somehow I ended up out back with them. From there, all I remember is we all hit the ground. Me and Tia hit the ground for some reason. And then I remember feeling this pressure in my rib cage. And it took me a minute to realize he was nonstop kicking me in my ribs. So all I could think
When you
of
say he, who is kicking you in the ribs?
Wilson.
And where was Tia while you were being taken?
She was on top of me, hitting me in the back of the head, which caused me to go ahead and put myself in a fetal position. So all I could think to do is cover your head, cover your face. So I covered my head and my face as much as I could. I let him continue to kick me in the ribs because I couldn't get my arms into my ribs. I wanted to cover my face because I was like, if he goes for my face with his foot, it's over.
Okay. So, and at this point, you've gone from inside the residence to that little area just outside where the patio is?
Yeah.
All right. And you heard the 911 call earlier that was played.
Mhm.
The female voice on that call, was that you?
Yeah.
All right. And the male voice, was that Jesse?
Yeah.
And when you're outside and this is happening, do you remember where your phone was? Because you weren't talking to the police anymore, right?
No, my phone was, it took me forever to find it. Actually, I thought they'd stolen it, but it was outside laying in the yard, pretty far from where I was being kicked. So I guess it must have flew out of my hand and went flying from there.
Which is why you can hear on the 911 call the things happening outside.
Yeah.
Okay. So when they ultimately left, did they take anything with them that had been inside the house?
No. They seen that the dog was running around in a circle in the backyard. She was going crazy. She was very stressed out. She did not understand what was going on. Tia ran, picked up the dog, and then I heard Wilson yelling, "Hey, hey," to somebody. And then I seen lights pull up. They jumped into a car and they booked it off.
Okay, so they took the dog with them?
Yeah.
All right. And what, if any, injuries did you have as a result of what took place?
At the time, I didn't really know that I was hurt like I was. I had adrenaline rushing through my body so much that I didn't feel anything. So I told them, since they only brought one ambulance, just take him. He was hurt the worst, but I will deal with it. I told the cops like how he kicked me and stuff. I didn't feel it really until that next morning. And that's when I couldn't get up. I couldn't move. I couldn't breathe. Like it felt like I was dying inside from how bad he kicked me. And it still hurts. I'm not going to tell you where I work, but I'm going to tell you I wear an apron where I work. When I have to button that thing around my waist, it goes in between my ribs now, and it aches me to the point I can't breathe. It hurts, and I can't take it off. So I'm stuck there constantly in pain still every day.
Okay. So let me show you up here on the screen a photograph that's been marked as State's Exhibit 2C. If you would tell the court what 2C shows.
That's my back.
Okay. And it doesn't show up as well on this, but let me show you. The redness that we see in that picture, what's that from?
I mean, the bigger red part right here, this is obviously some blood. Some of this redness is probably from where he kicked me. It looks a little bit bruised right here, so that's probably the bruising that he did to my ribs.
Okay, so all the injuries we see in this picture are the result of the defendant, Mr. Rivera, kicking you.
Yeah, kicking nonstop. I thought he was going to kill me out there.
And then you mentioned that Ms. Spradlin also was hitting you, is that right?
Yeah, she's hitting me in the back of my head. So I had like tons of little knots in the back of my head, which, yeah, it's nothing compared to what he did to my ribs.
But when she was hitting your head, did you also experience pain as she was hitting you?
Yeah, I knew she was hitting me, but I kind of blinded that out from the fact that I mainly felt the pain when him nonstop kicking me in the ribs. He's nonstop kicking. She's nonstop punching the back of my head, and it just won't stop. And he's out there yelling, "Stop, stop, you're going to kill her." And all I'm thinking is, I'm going to literally die out here. This is how I'm going to die, with him kicking me to the point that my insides just bleed out.
So how is it that this ended?
Ended because he was screaming and begging him to get off of me, and I guess Wilson must have realized I'm down, I can't get up, I can't move, and he finally stopped and ran.
Okay, so the two of them ran away and took the dog.
Yep.
So when the police arrived, were you still present?
Yep.
And was your husband still present?
Yeah, I had to go back out to the neighbors and have them call 911 again.
Okay, but the question is when the police arrived and the ambulance arrived, you and your husband actually stayed around to speak to the police.
Yep.
Did the defendant, Mr. Rivera, or the defendant, Ms. Spradlin, did they stick around to tell their story to the police?
No, they ran as fast as they could run.
And to your knowledge, did you find that knife in your house? Was that knife ever
No.
recovered that he had?
No, we looked outside, we looked in the house. I wanted to find it because I wanted to give it to the cops so they could get the fingerprints off of it.
Okay. But it was never
I never
found.
found it.
All right. And everything you testified to happened at that Brandywine address in Warren County, Ohio.
Yes.
That's all the questions I have, Judge.
All right, thank you. Cross-examination.
Thank you, Judge. 1 second.
Good morning, Ms. Hall. You indicated you're married to Jesse Eitzel, is that correct?
Etzel.
Etzel?
Yes.
Okay, are you legally married?
Not legally, no. We've
You
been
did-
together a pretty long time, so it's
Just refer
now
your,
it's pretty much marriage. I mean, we have kids together. That's
Okay.
is what it is.
and you indicated your children were in foster care, correct?
Yeah, they were.
Okay, and how many dogs did you have in that apartment?
Doing. I had 4 because I had just gotten a husky as well because my pit bull actually passed away.
All right. And then at some time, you invited the co-defendants today that you identified to live with you, is that correct?
Basically, if you want to call it that.
Okay, and they came at your invitation, they didn't just show up, right?
Yeah, they came at my invitation.
Okay, and you allowed them to live there,
Yes.
correct? And you gave them some baby clothes, correct?
Yes.
And at some point, they ended up not coming back to stay with you, correct?
Yep.
Were you arguing when that occurred?
They were arguing because they were mad I wasn't going to let them come back. I mean, I had nothing to argue with. I had the house.
You know, why is it that you simply would not give them back their baby clothes?
They were my baby clothes. They were going to be used again when my son came out of foster care, which they knew. They were being allowed to borrow the baby clothes. I gave them chances to go get their own stuff. I showed them places they could get diapers, free clothes, everything. They refused to get.
Do you have, did you watch them 24/7?
I mean, if they were there, then yeah, pretty much.
You have no idea if they went and got their own baby clothes, do you?
No, they never did. They just used mine. Actually, the day that she gave birth, she asked me, she said, I wish I had some money to go buy the baby an outfit with so we could take his first pictures. I gave her $20. So here you go, get him his first outfit because I know how special of a moment that is.
You were present in the courtroom when Mr. Eitzel testified, correct?
Yeah.
Okay, and you heard him testify that he threw the clothes away?
Yeah, he did.
So he threw your clothes away?
Yep. My son has outgrew all the newborn stuff anyway, and after a while, when your kids are in foster care, it's like mourning a child that's still alive. So I was like, go ahead, throw it all out. I'm tired of looking at it. He gets to come home. We'll buy him all brand new stuff just like he deserves.
The night that this incident occurred, you heard your husband or paramour testify that a grown woman first came to the door, correct?
Yes.
Were you aware that that was my client's mother?
No, I was not because I've never actually seen his mom before.
And did you hear that conversation?
No.
At some point, these two today came to your house, correct, that night? And didn't, in fact, you tell them to go around the back?
No.
Didn't they knock on the door? Wasn't it correct that they knocked on the door and you looked out the window and said, go around the back?
No.
You're denying that.
Yes, I'm denying that.
Do you recall hearing the 911 tape played?
Yeah.
And do you recall when your paramour said, stab him, stab him?
Yeah.
When you went into the kitchen, didn't you go in there to get a weapon or a knife to stab him?
I couldn't see anything. It was dark. All I could do was feel around. I found a coffee pot and I threw it. That was my best weapon.
Pay attention to his question.
I am.
Listen to it, then again, ask the question again.
When he said, stab him, did you go into the kitchen to get a knife or a weapon?
No, I was already in the kitchen on the phone with 911, so I felt around and all I found was the coffee pot and I threw it.
You threw a coffee pot.
Yeah, I threw a coffee pot.
All right. And at any point, did you get involved in the altercation with the two co-defendants?
I mean, apparently, because I was getting kicked and beat the crap out of outside.
Did you go to the hospital?
No, I didn't. Only one ambulance showed up because somebody called them and told them not to come to our house.
Did you ever receive any medical treatment?
No, I did not.
1 second, please.
Nothing further, Judge.
Cross-examination.
No, my colleague did a great job.
Okay. Any redirect?
Just a couple questions, Judge. Ma'am, did you or Jesse ever in your presence invite them into that home? That night on August the 1st, 2025, when the incident that you described took place, did you invite them in?
No.
Okay. So when they came in without your permission.
Yes.
And this, you described this apartment, at the time that this happened, that was the permanent residence for yourself and Mr. Edsel.
Yes.
No further questions, Judge.
Any follow-up questions?
No, sir.
Okay, you can step down. Next witness, please.
I have just a moment, Judge, please.
Yes. Why don't we just take a break?
Sure.
Okay.
At this time, the people would be moving to dismiss this case without prejudice.
And Your Honor, defense would make a counter motion to dismiss this case with prejudice and would ask to be heard on that. Go ahead. Your Honor, thank you for the bench conference and the chambers conference earlier today. We move that this court dismiss this case with prejudice under People v. Williams and People v. Hill. In People v. Williams, the Supreme Court said that the state Supreme Court reiterated the defendant's right to a speedy trial and issued a 4-factor test for determining that. While there's no 18-month fast deadline with misdemeanors, there is still a balancing test that applies to misdemeanors, specifically factor 4, which looks at actual prejudice to the defendant. And here there would be 2 forms of actual prejudice if this court were not to dismiss with prejudice. First, as it relates to this case, we're here, we're ready to go. My client has taken time off work. He's incurred legal fees. He would continue to have to do so if this case was reauthorized, as the people have indicated could occur. Second, as it relates to the divorce case concurrent between these same parties, the state court administrator's office recommends a 6-month window for non-minor children DO case divorces. We're about 45 days from that with the final settlement conference scheduled in late June. If we were unable to break the roadblock in the divorce by solving this matter, it's possible that the circuit court would dismiss that case, forcing to restart the divorce proceedings because the scale recommends that they dismiss if they aren't solved within 6 months without prejudice and refile. Additionally, there'd be extra legal fees. Yeah, but wouldn't the circuit court's option in that respect be a trial?
The circuit court would have the option to be a trial.
Okay.
However, my client would continue and has faced increased legal fees in that case as well because of the roadblock and not able to make progress while this is pending. I'll also add a few things that I find notable, which is if the people were prepared to proceed today before additional evidence may or may not have come to light, why would they not be able to proceed today without that additional evidence if they were truly ready for a bench trial today? And notably, the complaining witness here has decided not to proceed and asked to dismiss without prejudice. However, he would not be prejudiced if this court were to proceed today because he would still be able to testify, the officer would be able to testify, and the court could review all admissible information. The Michigan Court and Court Rule 6.004 are clear that when a defendant's right to a speedy trial has been violated, the appropriate remedy is dismissal of the charges with prejudice. In that case, cite us People v. Hill 144 Mich. App 735, 1985. We believe that's applicable here, and we believe that this court should dismiss with prejudice as not to prejudice my client further.
All right, thank you.
And Your Honor, the people would ask for the case to be dismissed without prejudice. This case was arraigned in January, I believe January 27th. At the first pretrial was set for final settlement, and the court had final settlement on April 10th, I believe. There's a potential that this case could be reauthorized as soon as this week after further investigation is done, and it could be back on the trial docket for next month on the 27th date of May. Further, it's the people's decision to bring the case to the court when it is a complete investigation with a full picture. Based on the evidence that I've discovered this morning, I feel there needs to be some additional investigation done with regards to that before bringing a reauthorization to make sure that we have a complete picture for this case. So this time I would be asking for the case to be dismissed without prejudice.
If I may briefly respond, the information requiring additional information is available in Odyssey and would have been available to the prosecutor as of December 26th, the day after the underlying alleged incident, as well as the prosecutor's office would have had the opportunity, the people could have communicated with the victim. The victim in this case has retained a counsel in the divorce matter. He was able to go and file a PPO the day later and understand that process. There's no reason this information couldn't have been available and investigated at a much earlier juncture than it is today. And while I understand the people's request, I don't believe that my client should face any additional prejudice in either this court or the 20th Circuit Court with delays allowing for additional investigation.
Thank you. The court will dismiss the case. I think certainly, Mr. Foote, the arguments that you bring up on behalf of Mr. Champion regarding what might be potential prejudice, I'm not sure that this court could get to the point of saying that's actual prejudice at this point. At some point, it may be indeed actual prejudice and actual prejudice that you have to show to the court. And but I don't think it rises to that at this juncture. I would also indicate that while there's this other evidence that came forth, had a PPO been granted, I think I would hold the people to a higher burden of saying you should have seen that. A denial becomes a whole different sort of issue of what somebody may be looking at as they're preparing the case. What I'm going to do is I'm going to dismiss the case. I'm going to dismiss it without prejudice. However, that is also without prejudice to the arguments that you raised today, that those could be brought back before the court. And I would say, given at least what the court is aware of regarding this, that people should think very carefully when bringing it back. As to whether or not that's really a suitable thing to do. So it's going to be without prejudice at this point, but certainly the arguments that you've raised can be raised again before this court.
And thank you, Judge. If I may briefly for the record.
Yes.
Under the case law on a speedy trial, we just want to state for the record that we are asserting that right, and we will be bringing a written motion to dismiss if the people reauthorize.
Understood. Understood. And that's what I mean, I think that may be the appropriate point to do it if that becomes an issue. All right. Thank you. Dismiss.
Your Honor, briefly also, can Mr. Champion go to community corrections to have the tether removed?
What?
Have his tether removed.
He doesn't like it?
I think he wants to
No, you give people, Alan, we give people gifts. Then they want to give them back to you. Absolutely. Well, and make sure to let them know that the case has been dismissed so that we can go over there. You shouldn't have a problem. If they do raise any issue with you, just tell them to call my chambers. We'll take care of it.
Thank you, Judge.
Thank you.
Okay.
You do the same. We're going to be in recess. Court stands in recess.
There's some cricket thing going on. Echo. Yeah. So, state was ready.
Case.
Okay, Marvin, you're
Yes, Judge.
up next on Barlow.
On Barlow, Judge, I have a witness that we've bench warranted here that some kind of way got sent back to TDC. So we're in the process of getting them back.
We just need I think a week or two on that, but if we can, just.
Like a night court episode.
Yes, sir.
It would be a comedy if we. Big comedy routine.
Thank you, Judge.
Yeah, okay. What else can we do? I'm not gonna drive over and get them. Alfred Washington.
Judge, that case is ready. They want to bring something to the court's attention because I don't know if you'll want to deal with it before trial or during. There's a mismatch in the 911 recording and the 911 call sheet dispatch log. So there's going to be a question as to whether or not that equipment was properly functioning at the time.
Okay. Listen, doesn't sound like anything unusual. Every case seems to have pitches, and we deal with them. We move forward. That doesn't rise to the James Byrd murders that I tried. It just seems like that's not as a significant problem to deal with as some others that I've dealt with. We'll just move forward. Orlean Neely, you're ready.
Yes.
Orlean Neely.
Although I am in trial next door.
Yeah. That's John West. Where's John?
He said he's ready, Judge. He's running a little bit late.
No.
He told me that as well.
Okay, you're Mr. Neely, I guess.
Yes.
John West is your attorney.
Yes.
And he announces ready, so we may be trying this case today. You might want to go borrow a tie from someone. That's not the way defendants normally look in a trial here. This is like.
I've never been to a trial.
Well,
I don't know nothing.
Mr. West should tell you about that. This is a court of honor. I mean, look around. Do you see, look at how many ties do you count? Do you see anybody without a tie? I'm talking about, you want to be a funny guy? I'm talking about the men here. Do you see anybody?
Yeah, I'm saying.
Okay, that just shows respect for the Constitution of the United States, sir. Have a seat. Brandon Richards. Can't make this stuff up. Ready? Yeah. Tommy Williams, where are you? Tommy, that's you? Where's Tommy? That's going to be Judge John West. Tommy Williams III, cause number 24CR1719. No answer in the courtroom. I asked the bailiff to call into the hall for Tommy Williams III.
Just.
What's his bond?
It's my birthday. There's no response.
No response to the name called in the courtroom. No response to that name being called in the hall. The defendant has failed to appear.
Does it look like he was arrested?
24CR1719. Was he or was he not?
Yeah, he's in our county jail.
Okay. What's he arrested for?
Oh, wait. So there's the company.
Criminal trespass. We can get him here this afternoon if need be, because
Okay. Yeah, bring him so we can explain what his problems are on this other case. Tristan Jones.
We resolved this morning.
Otis Pollard. Langston. Has anybody seen Langston?
I saw him earlier this morning. I think he was in the back.
Hold on. Mr. Pollard,
He said,
what are we doing with that?
Judge, this is our first trial setting on this one. I was just gonna ask for one.
It's a year old, a year and a third old. That's old for most courts. Not for ours.
If I have to be ready, I'll be ready, but I was just gonna ask for one research.
I mean, he's in the list, okay.
I saw your email.
Which one?
A video. I need time to look for that, look into that. So I don't know if you wanna.
Right, well, what she's talking about, Judge, is that Beaumont PD is not him. Beaumont PD, what they submitted was one of the officers' videos from the date going to my client's house. I think we were looking for some other videos. But he did come to my office and I did go through a lot of that with him.
All right, he's got two cases, one's state jail felony of theft, the other is a third degree felony of unlawful possession of a firearm. And
yes, sir.
Is this right? He's a habitual felon?
Yes, sir. And I told him he looked
okay. We're going after them. We're going to try that firearm case, 25 to life.
Yes,
all right. And if we don't do it today, we're going to put him first every week. Tell him that. Okay. Because that needs to get resolved.
Thank you, Judge.
Sophie Martin.
Appreciate you, Judge.
Yeah. Mr. Jeffrey. Yes.
Judge, I made an offer that I know will resolve the case, but there was a family member that came up that said that there was a little bit more information that's happened since I made that offer. And so I just need a week to look at it and we'll probably plead it out. Huh? 2 weeks. That's fine. We'll get it taken care of though.
We said, Daquan Pugh.
Hey, Jude.
Hey.
Hold on. Okay. Hey guys, hold on.
Everybody stopped when he said, hold on. On Daquan Pugh.
This is my first judge. They just released discovery to me.
Where's he work? Where's he working? He's got a nice fancy little,
So
that thing glows in the dark.
Yes. This is Mr. Pugh, Your Honor.
Okay.
As I said, Judge, I just had discovery released to us out in the lawyer who's here. Give his name.
How many times is he gonna get lawyers till we can, he stops and he says, this is the one.
I believe
I don't think he'll choose another after Mr. Johnson will.
I believe I can get it resolved, Your Honor.
So what kind of time do you need?
Just a regular reset, Judge. I just got to go through the discovery.
You've been in here before. There is nothing regular about this room.
That's true, Judge. That's true. But
like a
Mr. Laird,
Saturday Night Live episode.
Mr. Laird released it to me, Judge. You're going to go through it this week, and I'm just whatever your standard time frame is.
It's 3-4 weeks. Well,
that'd be fine, Judge. 4 weeks will be fine.
Okay.
Thank you, Judge.
Get a reset.
Thank you all. It's good to see you.
Good to meet you. Okay.
I'm sure. Should. Yeah. They're either. I apologize. I got permission from another defendant. We are going to do the plea on her today. Sophie Martin.
Oh, she's on second. Same match. Okay. Let me know when that's done. Also on Tristan Kelly, Tristan Jones, Mr. Kelly, when y'all are ready, let me know so you can get in and out. John?
Yes, sir.
Your name came up a several times here. Orlean Meeks, Tommy Williams.
Ready, Patricia Eglin. I don't think the state wants to move it.
Hold on, I don't even have a Patricia Eglin.
And
This is Orlean Neely.
Ready on that one.
Tommy Williams, third.
Yeah.
Okay.
Okay, it was already taken off. We talked about it. So I have two, Your Honor. Ready on.
Let's make it two.
Okay, all right. In this order, we're gonna have Burbanks, Haji Myers, if he's not in trial somewhere else. Horatio Trevino is 2, Ryan Gertz, and Mr. Reynolds is 3 on the injury to a child, Kenesha Hawkins. That's right, we said. How long did we do that for? Reset.
Not long, Judge. That's the one, Mr. Laird,
On Kenesha Hawkins, that's gonna be reset.
Yeah.
But
Yeah, I need to speak with Buddy too about something, offer.
y'all decide how long, okay?
Yes, sir.
Let us know.
Not too long.
And then, then Alfred Washington is 3. And John Orlean Neely, that's 4. Okay, that ought to keep us busy here. Thanks. These. Might need a few, they're gonna know.
yes, sir. Oh, get them to you. Here's the 9:30 docket.
Thank you very much. I didn't get you anything.
We need Tommy Dillon. We need him or not.
Yeah.
Hey, Donald, Brandon Dorsey. Hey, Donald.
Yes, I have. Oh, sorry. We're ready to go. He's in custody.
Okay, I need Brandon Dorsey, please.
Sorry, I didn't realize you were on that docket.
Yeah, well, I'm gonna stay ahead of the game. That's possible.
And yeah, we can think it's easy problem. Yeah, so it's going to be, I think this will be here for no problem. All right. So you have.
19-33584 is now called the State of Texas versus Brandon Lee Dorsey. Is that you?
Yes, sir.
Present, is it your attorney, Mr. Dusler, and the state's attorney? There is a motion to revoke unadjudicated probation that's pending here. What are we going to do today?
Judge, we have an agreement, for a 1-year state jail if the court approves that. Otherwise, if you don't approve it, then I think the probation office is agreeing to put him back on probation, back in safety.
They want him to get some services, put him on the mental health caseload and get some services and get him some help.
Okay, well,
And
he's competent or not?
He's competent. He just has some mental issues, some cognitive issues, I believe, that they want to deal with some help in the mental health caseload.
We have a lot of that in this room. Now.
Well, you keep staring at me when you're saying that, and I understand why.
No, so the man is competent.
Yes, sir.
Yes.
what are we gonna do then?
Well, he has some jail credit. He'll accept the state's offer of 1 year state jail if he wants to go along with that.
What's in his best interest?
Probably to accept the 1 year state jail because he's got a bunch of credit and he'd be released relatively soon.
And then from the state?
But talk to probation, she's dealt with him more than I have.
We wanted to continue him on probation and put him on the mental health caseload.
On the what?
We wanted to continue.
The intense
mental health.
No, just the mental health.
health caseload. Why?
He does have a traumatic brain injury, and he recently went to Spindletop and he was diagnosed with bipolar 1 disorder, and he was prescribed medication and everything, and we wanted to keep that going. And the treatment that he needed.
Okay, what happened on this allegation here that he failed to obey all the rules of the substance abuse felony safe P. If he fails to do that, why would we think he would be successful in other requirements?
His original counselor that he had while he was in treatment passed away, and they were aware of his limited cognitive abilities, and the new counselor that he was assigned to, they were not aware. So the extra assistance that he was receiving, he wasn't.
How could they not be aware? I mean, isn't it in the file? I mean, isn't it paperwork everywhere, or did they have, or was the head in the sand? Okay, don't answer that. The application, though, what did he fail to do that he should have done?
Attended groups.
How many group sessions did he fail to? 10 before finally a motion was filed.
He was instructed to attend weekly.
And
He was instructed to attend weekly.
and how many did he fail to attend before? Does it show when
Let's see if we
kind of became AWOL? Does Mr. Dorsey have a plan of getting some kind of treatment or help if he goes to state jail and then is released?
I think he was continue
Is what he does?
right. That's what you've been doing.
Yeah, I was continue spending something. Yes, sir.
I had the Spindletop.
Were you at the Spindletop facility before you committed this offense? Or is it just since you committed this offense that you went to the Spindletop?
I did go to Spindletop.
Before all of this?
Yes, sir.
When did you start going to Spindletop? Do you remember?
No, sir. Because I got
Like years ago?
I can't recall because I got amnesia. I can't recall what day I started and what day I stopped.
Judge, he was just assigned, I think the aftercare requirements was ordered in February of 25. And as of January 29th of 2026, the defendant was unsuccessfully discharged from the Cheyenne Center. He repeatedly missed groups at the center, even after he was assigned a positive peer to remind him to attend, is all I have on the report. But
Gotta help yourself, you know? Okay, from probation. What happens if he doesn't? What happens, Scott mentioned? What happens if we just give him credit for time served, I guess, for a year? Is that right? He's got about a year service?
He's a little less than that.
Okay, so he does a few more days, but then he's released. What's going on to help him do what he needs to do? Because we have a. Can I see the pre-sentence sheet? Yes, sir. Thank you. You know what I'm looking for is criminal history.
just for the clerk's edification, the restitution of the case, I think, has been paid off. So
Unauthorized use of a motor vehicle, stealing cars. I'm looking at this four different types of dispositions, not only in this county, but in Liberty County, Warden County, Taylor County. That's a lot of unauthorized use, stealing cars in different counties. Why'd you do that?
Because the person I was riding with, they told me they was
4 times. This is 4 different counties.
What they told me they was their vehicles too, sir.
I'm sorry.
They had literally lied to me and so
Other people lied to you?
That was their vehicle, but I didn't understand. I didn't know that wasn't their vehicle until I got the law pulled me over and told me this is a stolen vehicle.
Well,
they told me that they were their vehicle.
Okay, but you were put on probation here before me, right?
Right.
For unauthorized use of a motor vehicle. Did you lie to me when you were entering your plea and you said you were guilty? I swear to God. That's what you said. I swear to God, I am guilty.
I didn't lie to you.
Okay, so you were guilty of that?
Yes, sir.
Okay. The other findings where you were placed on probation, you would have had to say the same thing to the judge. That's normal. That's the way we do things in the law. Were you lying to them when you said you were guilty?
No, sir.
Well, somebody's wrong. I don't think it's the judge. They follow kind of a rule of procedure under the law. Do you think you need more assistance that we can help you with? That the probation office has been helping you with? You have to attend, but it's in your best interest. I'm looking here, Mr. Gray, and I think you still need some assistance. That's in your best interest. I'm not talking about staying in jail. I'm talking about being assisted when you're out under my supervision and going to see medical treatment to ensure that whatever problems you have get corrected and get fixed. And it's, from what I'm reading here, this is fixable and you can deal with it responsibly and live a very happy, responsible life. But it's obvious that you still need some care, and that is in your best interest, I believe.
I also want to point out to the court, I've got a letter that I received from his mother. It says that as soon as he gets out of jail, that she is working on getting him some doctor appointments to deal with his brain injury and his conditions there.
All right.
And so she's just asking.
How about that? Would that be good if we can get you out of here?
Yes, sir.
Here's the problem, though. What we're going to end up doing is, for this, the criminal history is replete with problems. What the court wants to do is revoke his probation, find him guilty, sentence him to time, sentence him to 2 years, give him credit for time served, place him on regular probation now. This is the only way to keep this supervision.
Sure call.
Yeah, I think that's the way to do it. He's been in problems enough.
So this is a 5-year probation, judge. You can just extend him up to another few years. You don't have to go to the revoking. We can.
Well, he's on, but I mean, the problem is what he's charged with again.
Yes, sir.
And this is not following the rules. And
yes, sir.
This was to help him to go to the residential treatment center. I mean, what I don't want to do is open a door. What's good for Mr. Dorsey is good for everybody else. I send somebody there and then they don't go. We catch them, bring them back, and then they say, well, I'll go from now on. I want the Brandon Dorsey rule. What's fair is fair. And that's why I don't want to open a door. You were ordered to do this. You didn't. You got to pay a price. And that's what I'm suggesting that we do here. That's what I want to do. Revoke him, sentence him, place him back on regular probation now. Okay? And him get the treatment that he needs. We all know it. He's not doing well on his own treatment.
Your call.
All right, Mr. Dorsey, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand, sir.
Does the defendant waive a formal reading of this motion to revoke unadjudicated probation filed on March 9th of this year? Can we
Yes.
proceed in summary?
Yes.
In summary, Mr. Darcy, this motion to revoke probation states that on May 4th, 2022, going on 4 years ago, that you were placed on deferred or unadjudicated probation for a period of 5 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true?
Yes, sir.
Allegation 1 states that you failed to obey all rules and regulations of the substance abuse felony punishment program. We call that SAFE, and SAFP, we call it SAFE, and you were unsuccessfully discharged from the Cheyenne Center Residential Aftercare as part of the substance abuse felony punishment program because you failed to fully participate in the program as required and as directed by the court. And that was a violation of a special condition of probation, which was added to your probation on February 4th, 2025. And is all of that true and correct, sir?
Yes, sir.
Are you pleading true and correct for this voluntarily and because it is true?
Because
do you understand that
it is true.
a voluntarily and made plea of true to one or more violations of probation, that is enough to grant this motion to revoke probation? Your deferred or unadjudicated probation can be revoked, and you can be placed on either a regular probation, and you would be found guilty, placed on regular probation, or you could be found guilty and then sentenced to the state jail for up to 2 years. Those are the two options. And what I'm proposing is placing you back on probation. Nonetheless, are you pleading true, knowing all of this voluntarily, and because this allegation is true? I find that you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Here's what I'm going to do. Anything else to add? I'm going to find, if nothing further, that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater, as allegation 1 is proven true, and by a preponderance of the evidence. And thus, this motion to revoke unadjudicated probation is hereby granted. Earlier in this case, you pleaded guilty to the state jail felony of unauthorized use of a motor vehicle voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your plea hearing originally to find you guilty beyond a reasonable doubt. We deferred any finding of guilt. Now, this motion to revoke probation is hereby granted. I therefore now find you guilty beyond a reasonable doubt of the state jail felony of unauthorized use of a motor vehicle. And you are hereby sentenced to confinement in the state jail for 2 years. But I'm going to suspend that confinement and place you on regular probation for 5 years. You have already served about four. So you're going to be on probation for kind of about 1 more year or so. And you will be ordered to.
No, Judge, once you revoke him, if you do 5 years, I guess you could release him early, but he's going to be on for 5 years probation.
Well, okay, the most we can put him on then.
Ms. Nicholson's here on behalf of the state of Ohio. We're here for an early termination hearing. Ms. Nicholson, does the state have a position?
I'm just checking real quick, Your Honor, to make sure we haven't heard from the victim. I don't believe that we had. Just 1 second. We have no position, Your Honor. And we did not receive any contact from the victim.
All right, anything else from probation?
Nothing further, Your Honor.
All right, the court finds that Mr. Childers has satisfactorily completed the orders and conditions of his supervision, and we will terminate his supervision at this time. Well done. Congratulations.
Thank you, Your Honor.
That's all. You're free to go.
Thank you. Have a good one.
Lily, do you need him for anything?
I do not.
All right.
You will get a copy once everybody signs it in the mail, that you are good to go, okay?
It should be the next case on the docket.
Oh.
Unless they're out of order. They haven't mixed on the docket. No, this was state case. Okay.
Okay. 24 CR 889 is called You are Dolan Alvin James McMillan. Present with Mr. Dusler, your attorney, and the state's attorney. There's a motion to revoke probation. Earlier, you had pleaded true a couple of weeks ago or so, 10 days or so, to committing the offense of theft. And you're on the second-degree felony of burglary of a habitation. It's regular probation, sentenced to 10 years in prison, probated for 10 years. And we reset this to continue this hearing on this day. And what's our plan?
The plan was that he was to pay the balance of restitution, which was $350.
Was that done?
Yes.
Okay.
And then you were going to hopefully favorably consider reinstating on probation if he did what he was supposed to, that you asked about family restitution.
There wasn't an agreement to that, Judge, as my notes reflect that the state had asked for 5 years TDC. He, of course, you understand, is requesting that, but there wasn't an agreement in that regard.
That's correct. There is no agreement.
How much time does he have for this? I mean, I see the I don't even get to say the whole word. Or you did something.
Yeah. It's an accident, Judge. It's not going to happen again.
You know, you're way ahead of time. I'm sorry, how much?
I'm calculating this.
55 days.
That's what I'm saying.
Whatever happened to Dewan, his brother, on this?
I don't know that answer, Judge.
Okay.
I'm picking this file up from somebody else's caseload, so I don't know.
Yeah, I think I see what I need to see. Thank you on that.
Good judge.
Just a little bit.
All right. This is this. See a little triggered stuff there. Yeah. Maybe it. You know where I take it. What are you talking about?
All right, I think I understand what you're here. The defendant was placed on probation, regular probation, for the second-degree felony of burglary of a habitation where it is alleged he intentionally and knowingly entered a home habitation without the effective consent of the owner with the intent to commit theft, and was placed on regular probation for that for 10 years. And then a motion to revoke probation was filed alleging, among other things, that the defendant committed the offense of theft of property on or about December 10th. And it looks like he was caught stealing from Dillard's. Is that wrong?
It's correct.
And he'd been on probation for about a year and a half. And I'm looking at 231. Nope, that's not him.
No, he's not.
It's about how much? 55 days. Just beginning. All right. The state is asking for revocation, I guess.
Yes, sir.
What's the defense say?
Well, you were concerned about the initial restitution of $1,000.
Yeah.
That's the reason he got reset. He did what you asked him to do. He raised $1,000 and has paid that in full. And he realized that he made a stupid mistake doing shoplifting, realized he should not do that, but he's looking at up to 10 years in prison. But he's asking the court to favorably, since he did what you asked him to do, to consider reinstating him on probation, keeping him on regular probation, see if he can complete it successfully. That's right.
What is it about stealing that gives you a problem of following the rules over? What is it about stealing that gets you in trouble? You know, thou shalt not steal, you know, that's a rule.
Stupid decision, I learned my lesson.
I thought you learned your lesson when we put you on probation the first time for stealing, burglary with intent to steal. That's looking at 20 years. All right. Anything else?
No, sir.
Okay. Yes.
Judge, I think you know what my position is. He's on probation. He commits a new offense, and
this theft is what degree crime?
It's a misdemeanor
It's a
offense, Judge.
misdemeanor. It looks like it's above 100, but less than 750. Was that Class B?
Class B, you're on.
Okay. All right. I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as you have pleaded true to allegation 1, committing the offense of theft voluntarily, knowingly, intelligently, and you admitted that you did that. You pleaded true because it was indeed true. That now I can revoke your probation and sentence you up to 10 years in prison. Here's what I'm going to do. It's a Class B misdemeanor. I don't know if they filed something on the side on that, but you know better. You're going to pay a price. I'm going, even though I can revoke your probation, I'm going to continue your probation, but you're going to stay in jail for 3 months. You won't be stealing at least in 3 months, but even a misdemeanor theft has a price, and you're looking at 10 years in prison. So I'm going to modify the conditions of probation to add 90 days jail confinement. When you are released, you report responsibly and follow all the rules. You run out of chances now. Start living honestly. Can you do that?
I think, Your Honor, that probation officer had a suggestion if
Is there anything else we want to add as conditions of probation?
She wants to keep him, Judge. I just want to make sure she was heard. Yeah.
Okay.
Thank you, Judge.
Live honestly. Okay, anything else?
Yeah.
That is all. Thank you. Next on.
Latrevian Payne, he needs to be brought.
Latrevian Payne, what are we doing on that?
We have an agreement we've submitted to the court.
Okay.
Yes. This is Mr. Town, yours. Okay.
Over here, right?
Yeah, you see, just your finger.
Yes, sir.
Yes.
Raise your right hand for me, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you God. Okay, eat up your wall.
She says.
Right there. You get up one more time. And right off of the box. Okay. Here you go, stand behind the judge.
24 CR 1310 is called Latrevian Payne. That's you? Present with your attorney, Mr. Producer, and the state's attorney. Does the defendant waives a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about April 26, 2024 in Jefferson County, Texas, you committed the third-degree felony of engaging in organized criminal activity. Let's see, what did you do for criminal activity, organized criminal activity? Collaborated in carrying on criminal activity, including committing the offenses of burglary of a building and theft of a firearm. I need Mr. Pad. Let me get it. Thank you. Was in the trash. You understand what you're charged with, sir? That's a question to you. Okay. It's a third-degree felony, which carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can also be assessed. Do you understand? An agreement has been reached in your case where you would be pleading guilty, sentenced to 3 years in prison, given credit for all time you have served in this conjunction with this. Is that your understanding of the plan?
Sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand that, sir? How do you plead to this third-degree felony of engaging in organized criminal activity as indicted? Guilty or not guilty? I'm sorry. Are you pleading guilty voluntarily? That is on your own free will. And because you are indeed guilty of what the indictment alleges. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct here? State's Exhibit 1 tendered into without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea, It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Do you understand?
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is
Yes,
the highway. I'm going to follow this agreement. If nothing further to add by anybody, then fine. Mr. Payne, you are pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty of this indicted third-degree felony of engaging in organized criminal activity. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir? Anything else to add on this?
No,
Doc? Thank you. That is all.
Penalty.
Next.
But Megan Crestwood, she's here in the courtroom.
Forward, please, ma'am. One case on here.
Yes, sir. And we're just asking for 3 or 4 weeks on this one.
All right. Confirm. You are Megan McKenzie Crestwood?
Yeah.
In 25 CR 513, you have been indicted as of May 7th. This was a year ago?
Yes, sir.
Of the third-degree felony of promoting prostitution, which carries with it up to 10 years in prison. Do you understand fully what you're charged with here? So, what are we doing today?
Asking for 3 or 4 weeks to start first commencement before the court here.
What's taking so long to get here?
She's been in jail in Louisiana.
Been incarcerated for a year.
For
Same thing.
Same thing. I'll have that resolved in June. I'm out. I have an ankle monitor on right now. And then I go back to court in June and it'll be resolved.
Is that all you have pending other than this court?
Yes.
Nothing? No federal charges? Surprised the feds didn't pick something like that.
I know they've been involved in this. I actually received a call last week from someone, the FBI, that said that she had a threat on her life, so they were concerned about her. So
I'm talking about
but I
Mann Act.
think they're looking into it, but I don't know that anything's been decided there.
My attorney in Louisiana had reached out to the federal agent that was working on the case, and he said that as of right now, they're not pursuing charges federally.
Okay. Well, that's up to the United States Attorney anyway, at the end of the day, but. So you've taken care of your problems in Louisiana in this regard, and then is there any other state where you have pending matters? Okay.
There was one other state involved, but it's not, I don't think there's any charges pending there, Judge.
All right, so Don, again, what are you asking?
Just a 3 or 4 week reset.
Okay. 3 or 4? 4 weeks ago, you got it? Right. Okay. Who else, Don? Anybody else? That's it?
Yeah, that's it.
You're leaving now?
I'm out here.
See ya.
All right.
What do you, anything you want to announce or you want me to speak for you? Okay, you've got it.
Oh, I'm out next then? Yeah, I was just gonna be in front of the restaurant.
You go to the restaurant.
Where are you?
You run out of excuses, by the way, after this. Okay.
Yes.
We're signed up on Sophie Martin, I believe. Okay, off the trial document.
Sophie, okay, come on up.
Yeah.
25 CR 464 is now called the state of Texas versus Sophie Ann Martin. You were here with your attorney, Mr. Jeffries, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about February 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of making a false alarm or reporting an emergency improperly and illegally. Let's say this. And communicating a report of a future bombing at a public school. I guess that was a hoax. And you knew that the report of a bomb at a high school, local high school here, was false and baseless and would cause action by official agencies organized to deal with emergencies. For example, the Jefferson County Sheriff's Office and the Hampshire Fire Department. So this is a state jail felony. Do you understand fully what you're charged with? If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes. Okay, you have a soft voice. An agreement has been reached in your case where you would be prosecuted for the lesser included Class A misdemeanor of attempted.
Yes, sir. It's a state
Making a false alarm or report an emergency. Hey, listen.
You broke it?
I didn't intend to.
Judge.
I don't know what I touched. Y'all saw me. I wasn't trying to be harmful to the machine. Is that your understanding of the plan? Yes. Yeah, speak out. Okay. That means it carries with it, Class A misdemeanor carries with it up to 1 year in the county jail and or a fine up to $4,000. An agreement's been reached in your case. What?
1 year deferred probation. We put down for 1 year, no fine.
Correct, John. All right. Apparently the agreement is that you would be pleading guilty, placed on deferred or unadjudicated probation for 1 year. And there would be terms and conditions of probation, which would be normally customary for this type of offense. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand? Yes. If you fail, your probation could be revoked. If you fail to follow the terms and conditions of probation that we're going to go over with you here in a minute, you fail, then your probation could be revoked. You could then be found guilty by the court and sentenced up to 1 year in a county jail.
Yeah, may I inject just real quick? Her response is a little slow at times. She has a trouble with speech. So,
okay,
just didn't want any delay to the.
I think she speaks better than most of the attorneys I have, or she seems to articulate quite well.
In a minute, to restart it.
What happened?
I don't know.
Was it when I threw it in the trash can?
Maybe.
That slipped, by the way. So, are you in school now? Where at high school?
Homeschool.
You're homeschooled. What level schooling are you right now? What level are you in grade level? Senior? Yes? Okay, so you're gonna be graduating this year? Then what? Where do you want to go? You're gonna go to college? Which one? Lamar or something? Okay, what do you want to do?
Computer, engineering.
Okay, engineering. Computer.
Yes, sir.
Sounds like a good living.
Yes. Help you with
Yeah, can you work on that tablet that we're having trouble with? Just shut up.
Is there another tablet over there? I really don't.
About 50% level.
Working on this. Actually, for the time being, I'm gonna give you.
Okay, the agreement again is that she would be placed on deferred or unadjudicated probation. That can be up to 2 years, right?
Yes, sir.
Is that what y'all want?
We had agreed to 1 year.
Is that y'all agreed to?
Yes, sir.
All right, then that, it'll be done. Is there any fine or anything like that?
No.
There will be terms and conditions of probation, which are normally customary for this type of offense though, right?
Yes, sir. Correct.
Is that your understanding of the plan here? Yes.
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
We're working off a state jail felony, so give me a minute. We're gonna have misdemeanor punishment ranges that aren't written in.
I don't know what else we did. Place by us.
I follow this agreement again, you have no right of appeal. Understand? How do you plead to this again? Guilty or not guilty? The lesser included Class A misdemeanor of attempted making a false alarm or reporting an emergency. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence and without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and it's been read here. You've read it. You are guilty of the crime charged in any lesser included offenses such as this Class A misdemeanor that the parties have entered the agreement into that you are pleading guilty to. You are giving up your rights to a jury trial and the rights to the appearance, cross-examination, confrontation of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes, sir.
I will follow this agreement, if nothing further, and find you are pleading guilty to this lesser included Class A misdemeanor of attempted making a false alarm or emergency under this indictment, in this case, voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 182 to find you guilty beyond a reasonable doubt. But I'm going to instead defer or postpone any finding of guilt so long as you follow terms and conditions of probation. And this will be for 1 year, a deferred or unadjudicated probation. There will be terms and conditions of probation. The probation officer will go over them with you, make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. And that is day for day. So you don't want that. You understand what has happened today?
Yes, sir.
Please see the probation officer. Thank you.
Thank you, Your Honor.
Yes, sir.
She didn't call us.
You move it. As long as you and up to $10,000 in the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Oh, yes, sir.
In summary, this indictment alleges that on or about March 16th, 2023 in Jefferson County, Texas, you committed a state jail felony of forgery of a financial instrument. You understand what you're charged with?
Yes, sir.
This is a state jail felony. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
The agreement's been reached further. You would be pleading guilty and sentenced to 2 years in the state jail. And is that your understanding of the agreement?
Yes, sir. With the, but I need to confirm my time credited because I've been locked up since 4/19/23 and I haven't got out yet. And I know
you'll be given credit for all time you've served. If it's longer than 2 years, then you'll get out. As long as once the paperwork is all reviewed, which doesn't take but a day. But the agreement is 2 years in the state jail.
Yes, sir.
You are always given credit for time. All persons are to be given credit for time they have served. So is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Was there any loss in this?
Let's see.
I don't show any restitution claim by either party, Judge.
No?
Nothing.
Yes. That is something I confirm before I make this offer to.
She's house. His house. She just went to.
Again, if I follow this, you have no right of appeal of your case, sir. You understand? Yes?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial, the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is hereby waived.
Yes, sir.
I'm going to follow this agreement, sir. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. You were guilty of this crime and any lesser included offenses. I now find you guilty beyond a reasonable doubt of this state jail felony of forgery of a financial instrument. I am following this agreement. You are hereby sentenced to confinement in the state jail for a term of 2 years. Hold on. Sure. Did you get any money out of this? Were you able to get the $300 that was?
$300 check? Yes, Your Honor.
What happened? What happened to it?
According to the complainant, he was reimbursed that.
He got his money back?
He got his money back.
Okay, you know that for sure, huh? Everybody?
That's the note I got back in
All
20.
right, I'm looking at the, my coordinator has figured up. You have officially 706 days credit. This is 730-day sentence. So you still have 24 days to serve. But I'm sure that you're not going to get out of the jail. I don't think. Well, I mean, you'll serve whatever time is left. They'll know that. Then you'll be released, I believe. But that's what we have figured. I mean, you haven't fulfilled 365 days times 2, which is 730.
Since y'all had the hold on me, we're not going all the way back since I've been locked up.
You get credit for all time you have served, and she's figured that out. She's got a computer on it, and it's showing 706 days.
Okay.
That's when the hold was placed.
That's when the hold was
The day that
placed.
the hold was placed to today,
Okay.
706 days.
Which means you may have been serving more time, had certain time before the hold was placed.
Yes.
But they know.
About a year.
They figure, well,
About a year.
Then forget it. Then you ought to be out quickly.
It's okay. I'm a trustee at the county jail and I'm just going to.
Well, you know how, I mean, they don't like keeping people in longer than the statute requires, because that's problematic for both sides. So you should be released pretty quickly.
Okay.
All right.
Thank you.
Anything else? That is all. Thank you.
And Judge, I just have Mr. Jones and Peterson. He's suing Mr. Jones. I just want to, if you wouldn't mind, Judge, on him, just have this one here on him.
Who is this?
Mr. Jones.
Mr. Jones. That's Jordan?
Jordan Jones. That's a MTRP announcement. That was actually just one reset on him, just one. And I did speak with Mr. Champ, his probation officer.
Oh, you got 3 cases, right?
Yes, sir.
You're, so you're on probation for 3 aggravated robberies, right?
Yes, sir.
Okay, how much time?
4 weeks. That'd be perfect.
4 weeks. Okay.
Thank you, Judge. And then my last case, Judge, is Peterson.
Michael.
Yes,
Levine.
it's a female. However, I did talk with her about the NQRP, but she's telling me that she's hired Mr. Kimball. So I think that'll be Mr. Kimball's case. She's not, yeah. She's saying that she hires him.
Michael, I can be this.
So I should have done notice on that.
Not in this file.
Right. Well, you can tell the judge. You need to tell me that she's, because I went to talk to her about the case and she's telling me that she got someone.
In my down, but it's not what this.
Yeah.
We don't have anything filed, which is.
I can handle your understanding.
See, but why did the one call out of everyone?
Right. So, but I did give her the MTRP paperwork. I did speak with her about the case, but I didn't want to go forward.
You know, I'm looking at your name here.
My name is in there?
Your name, wife's name, back in June of last year. How can that be?
No.
Were you? No. I'm looking. Look, you signed it.
Right.
You signed a document. There was a certification of right of appeal. I guess this was when the defendant was placed on probation, I guess. Yeah. You represented her on the original case. Okay. So all right. You're hiring him. You're going to hire him.
He has, but already, I don't know why the notice wasn't filed, or if it was filed, it may not have been accepted.
Okay.
Could be stuck into district clerks.
All right. We'll just get that through. It was
bond set on her, you know.
This is, what is it now? This is a. What's the history on that? Because there was a motion to revoke probation filed in January. Then a first amended follows up in April here today, this month.
2-4 DCCR.
Failing to identify. Failing to report. Okay. Was she in abscondent?
She never once reported to probation judge on this one.
Are you kidding? You never reported for probation. That's what the prosecutor says. You were placed on probation in June and you never reported of last year.
When she was released, she reported for intake, and then after that, she never came back.
One time. When was she finally, what was the date on that? And what's the intake date?
September the 11th of 25.
Okay. And when was she arrested?
March the 10th.
Half a year later, huh? Yeah. Are you asking for a bond?
Yes, sir.
$100,000. Plus, if you can post it, GPS device, home confinement.
I'm a colleague.
That's the order of the court for what you've done. You're on probation. When you're on probation, you have responsibilities. According to what I've heard here, you failed miserably to your probation. I mean, you're on supervision, and this is no supervision. If 5,000 probationers that we have just decided not to report, it'd be chaos. What's good for you is good for everybody. What's good for everybody is good for you. You have to report it. You can't do anything else. All right. We're going to put this for a motion hearing, 4 weeks. Everybody, 4 weeks. Thank you.
I anticipate filing a motion for a competency evaluation.
For you or for her?
I believe I'm mentally competent.
Want to ask for both, Judge?
All right. No, for her. Yeah, file it.
Got Chris, Dr. Thompson, instead of the law firm.
Who's
Thompson instead of
no request?
Well, who's paying for it?
County or something.
Well, then, it'll be my choice. And Dr. Abraham is a licensed psychiatrist. Now, of course, he's about to lead a new group of, a new facility. He'll be the director, yeah.
What's the procedure? Is the one that else?
It's,
Also.
what you're gonna say.
It's not just maintenance.
Okay, we're ready to go. So that's the resetting. Next is, I have, Tom.
Yes, sir.
Come on up.
No
and-
approach.
Yeah, who is it?
Tristan Jones.
Tristan Jones.
President of the court.
Of course. I was just looking at the bailiff because he prompts me how to handle these cases. Understood.
Judge, I've got it.
And he needs to go in front of you first?
I'm already taking care of it.
Thank you.
Here you go, Judge. It was off the trial docket.
Okay. And 24 CR 215 is called the State of Texas versus Tristan Jones. That's you, sir?
Yes, sir.
Present with Mr. Kelly, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary?
Yes, please do.
In summary, this indictment alleges, sir, on or about October 1st, 2024. Wow, 2.5 years has gone by. In Jefferson County, Texas, you committed the third-degree felony of assault on a family member or where you had a dating relationship. You understand what you're charged with here?
Yes.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Get that. An agreement has been reached where you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $1,000. There would be terms and conditions of probation, which would be normal and customary for this type of offense. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
I lost my date on the computer. It dropped. Still the 27th, isn't it?
All day, Judge.
And
Well,
have.
that's when we started. Didn't know if things changed. It's already been long in this. How do you plead to this charge, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes.
I show you what's marked as State's Exhibit 1 there. Did you sign that document? Understand it? Discuss it with your attorney or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true at State, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here. Yes? What's wrong?
Nothing's wrong.
You got that quizzical look.
No,
Not opposed to waiving it, Judge.
Waiving what?
Waiving the PSO.
Anything else to add? If not, I'm going to follow this agreement and find you have pleaded guilty voluntarily and you were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer any finding of guilt, postpone it so long as you follow these terms and conditions of probation in this deferred or probation deferred adjudication order. These are normal and customary for this type of offense. You will complete this batter's intervention protection program and have no contact with the victim of this offense. Is that our plan?
We understand that.
Okay, I didn't know if there was an intent to try to resolve the issues. Because people make mistakes, and I just made one. Wrote with the red pen.
No objections.
They all look alike from here up. Mr. Jones, there are 35 conditions of probation, but don't be alarmed when you see that. The overwhelming but vast majority of these are conditions that all of us have to follow. Most of these are reminders to do the right thing. Commit no offense. We all have to follow that. Don't associate with disreputable people. Report as well. Don't use or possess drugs illegally. Don't become intoxicated. Conduct yourself in a professional, courteous manner. See all the kind. These are all the things that. Now, some of these are special and unique to this program, this case, and this is to help fix this so you can move on with your life. And this right now is set for 10 years. If you do well, it will be shortened to 1/3. You can do the math. That's 3 1/3 years. If you fail on probation, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. So what did Gene Kranz on Apollo 13 say? Failure is not an option. And that's the way you need to look at it. There will be a fine of $1,000. Please make sure you follow these terms and conditions. Probation office is going to go over those with you, sign them and begin probation and do well. Anything from you? Excuse me. Yes. There we go. John West, Joshua Gross.
Please, man.
It's like 3 minutes, correct?
We're not playing on too much. So the state is dismissed.
Fine, okay.
All right, it looks like he's going to be pleading guilty to two. One will be dismissed. Is that the plan?
That is, Judge.
The one to be dismissed will be
194.
194. Okay, he pleads for 192, 193. Joshua, is that you? Please go in front of that lady first. She's going to swear you in and.
Raise your right hand, you swear or affirm to repeat the whole truth and accept the copy document.
Yes. He's taking it pretty well.
Right thumb, right thumb.
I think he's confident.
Okay.
That conversation was a little.
We're all right.
We're gonna put, yeah, but we're gonna put him on the mental health case.
Yeah, he understands what she's charged with. He told me what happened. He understands what's going on, so he should the department's really good. He doesn't.
Like straight up.
Which is why he was in the hospital, which is what started all this.
Okay, you know, in front of judge, okay?
Are you Joshua Gross?
Yes.
Am I pronouncing that correctly, Sir Gross?
Yes.
You were here with Mr. West, your attorney?
Sorry, I love Mr. West. Haven't talked to him in 3 months since I've been here.
Okay.
But it's fine. You know. I finally have though. I have within these 3 months. I have talked to him.
Okay.
So glad to talk to him. You know, to see what my choices are.
Okay. Do you understand you're going to be entering some pleas of guilty?
Yes.
2 pleas of guilty in some cases that have been charged. A third case that you are indicted for will be dismissed. Is that your understanding of the plan today?
Yes.
Yes.
Yes, sir.
Okay. Does the defendant, who's here with Mr. West, his attorney, and the state's attorney, does the defendant waive a formal reading of the indictments and the arraignments here? Can we proceed in summary?
Yes, Your Honor, we can.
First of all, in 26 CR 192, Joshua, this indictment states that on or about January 18th, 2026, just a few months ago, in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant, which states that with the intent to assault, harass, or alarm this person, you know to be a public servant, namely a Baptist hospital nurse. You apparently, let's spit at the lady.
Spit on him, sir.
Spit on him. Jalen?
Yes, sir.
How do you spell that?
That's correct spelling, Judge. I confirmed it.
BJAYLINJA.
No, it's
The spelling in the indictment is correct.
the
Judge.
spelling is correct.
Yes, sir.
It's phonetically.
I've talked to that individual. They've approved
It's
this.
misspelled in the probable cause affidavit. They had the L before the Y. Jalyet is the way it phonetically looks, but it's Jalen.
Yes, sir.
Okay. The nurse, who are there to help you, and you can't be harassing them. This is a 3rd-degree felony, which carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. It's serious. You understand? 26 CR 193 is another case that you've been charged with on or about January 18th, 2026 in Jefferson County, Texas. This alleges assault on a public servant where you intentionally, knowingly, or recklessly caused bodily injury to a Jefferson County Corrections officer by striking that person in the face with your hands. Do you understand what you're charged with there?
Yes.
This is also a 3rd-degree felony, which carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're charged with in these 2 cases?
Yes, sir.
There's a third case that you've been charged with, 26 CR 194, assault on a public servant, which is to be dismissed as part of this agreement to plead guilty on 2 cases. Is that your understanding?
Sure.
In each of these 2 cases that are 192 and 193 that you're indicted for, that you were going to be pleading guilty to, these are 3rd-degree felonies. Each of them, if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
In each case.
Yes, sir.
Agreements have been reached where you would be pleading guilty and placed on deferred or unadjudicated probation in each case for 10 years. A 3rd case will be dismissed, 194. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Can I do it right now and have it done?
What do you say?
Can I go back on my deal and just have me sentenced to take the sign off for the time to go to prison?
Do you want to go to prison for the probation?
Yes, because I cannot do probation. I have no home, have no help, I have no income, no source of help or outreach. I just have to be going to prison. I'd like to sign off right now to go to prison. Go ahead. Under my own competence.
Have you ever been convicted of a felony before? Have you ever been convicted of a crime before?
Yes, I have.
Of a felony?
No, sir.
All right. You don't want a felony conviction if you can avoid it.
I'd like to.
It closes all kinds of doors of opportunities and you're not able, you lose rights, constitutional rights, like you're unable to vote, hold public office. There are all kinds of things that placing you on probation, a deferred or unadjudicated probation, means that as long as you do well, your record stays clear. It's not a conviction of any of this. Most of these terms and conditions of probation are the same terms and conditions of probation I have to follow.
Yes, sir.
Like don't commit a crime is the first one. I got to follow that.
Yes, sir.
Yeah. Pay your bills. Be responsible. Don't harm others.
Completely understand, Your Honor. Pardon my interruption, Your Honor. I understand, but before I stand to what I'm saying, and I would like to revoke my right to
okay.
To do what I'm talking about. I would like to go into to go ahead and sign for my prison time.
Well, you're looking at up to standby. And these are all 30 felonies. You're looking at up to 30 years in prison on all of this.
Yes, sir. I understand. I have no.
Well, I can tell you, I've done this. I've been in criminal law for a long time.
No one's ever wanted to do this or broken.
Yeah, I think people from time to time say it, but after they speak to their lawyer a little more, they understand that it's not a wise choice. That's what I'm going to do is if that's what you want to do, let's take a couple of days here and let him talk to you. You ask him all the questions about what else.
He did on the law book for my interruption. I wish to fire my lawyer right now.
And do what?
Scan on my own counsel and ask to sign to go to just be tried.
Have you ever done such a thing before?
Yes, sir. In juvenile court.
Oh, well, this isn't juvenile court. This is the big leagues. You're looking at 30 years in prison.
I don't want my lawyer anymore. I'd like to sign for him.
And who's going to represent you?
My son.
You think you're competent to represent yourself?
Yes, sir.
Why do you say that? How far did you go in school?
High school.
How far did you go in high school?
All the way through high school.
You graduated from high school?
Yes, sir.
Where?
Finished my 11th and 12th grade in all different places. So.
Yeah. All right. There's an old saying that's a very famous saying that is a wise one. A person who represents themselves has a fool for a client. And there's some good reasons. Some people, a few who are lawyers, who have legal experience may do well. But you're looking at 30 years in prison.
So,
And here, these are 10 years together. You do well. It ends in 3 1/3 years, a third. I can shorten it to 1/3 if you do well. 3 1/3 years.
part of my interruption, Your Honor, there's no way that I'm gonna be able to stay and maintain and even make my probation office appointment to be able to.
Why?
The fact I have no transportation, I have no.
Well, that we accommodate people who have problems like that. Some people are homeless and we work with you.
Not wish to be in the ward.
Sir?
I do not wish to be in the ward, no.
I'm sorry.
I do not wish to be in the.
Doesn't want to be in the free world. He wants to go to the prison, Judge.
All right. Well, that's one way to think, and you're entitled to your own ideas, but you can understand only a few people think that out of 7 billion people on the planet.
One of those 1% that.
It's not a 1%. It's less than that. But if you want to represent yourself, that's fine. You've got to do that intelligently with reflection. And Mr. West is going to continue to help you if necessary. You don't have to get advice from him, but he's going to be with you because everyone who represents themselves in 20 years has failed miserably. They don't do that. And it they end up being, if they follow through with it, most people change their minds realizing after they reflect that this is an unwise choice. And you're entitled to make bad choices, but you ought to make good choices. And this plan is fashioned to keep your record clean. You don't have a felony conviction yet, do you? No.
No, he has
not yet.
Arrest, but no felony conviction.
All right. You don't want felonies. It just, you lose innumerable opportunities, and all probation, and our probation office has a 93% success rate with probationers. 93%. We brag about that, and they move on with their life, and on deferred, they don't get found guilty. They move on, and they are the best they can be. If you think you're destined to fail, that's a really negative way to think, but you ought to be optimistic. I think that's the natural thing. Well, where's your family located? Do you know?
Mostly all dead.
They're all dead? Well, you've got siblings, don't you?
My brother's dead to me.
He's dead to you. Oh, okay. But he's still alive. You just don't have any contact with him.
Just on.
Okay. Well, what's going to happen is now this is going to. But it sounds like you've got some bad fortune, but we all do from time to time. Bad times, good times.
Dad wasn't around. Dad wasn't around. He was in prison in Dallas, Texas.
Where is he now? You don't know?
Never knew him. I know his name. His name Wild Bill. Never got to spend no time with him.
It sounds like a bad role model for you, but you're smart enough to know. Well, you've seen people make mistakes like your dad, right? You don't want to make the same mistakes.
I don't really know what he's done in life. I know he's
but
neighborhoods.
Don't you? What we've fashioned, Joshua, is what's been fashioned between the lawyers is an opportunity for you to walk out of here in 24 hours as a free man and make a life, make a family, and be a good role model.
I have a son. I have 2 sons.
You have 2 sons? Well,
I have many wives.
Well, aren't the sons needing a father? Not in prison.
They took care of. They don't know who I am.
Where's the role modeling?
They going on 9.
That's what a parent does. I've been a parent for 40 years.
Their moms are there and their uncles and their
They need a
grandfathers are
dad.
there and their grandmothers.
They need a dad.
No, that's
Well, not one that elected to go to prison rather than a chance to be a free person to handle responsibilities as a father and a loving family member and to set good examples. This is your chance to do that, right?
Pardon me, Your Honor. Pardon my interruption, Your Honor.
Sir?
Pardon my interruption, Your Honor. My 8-year-old son going on 9 and my 17-year-old son going on 18. They both know I'm in here, and
He's 25, Judge.
Who is?
This man.
they both know that I'm in here.
Wait, you have how old is your oldest child?
17 going on 18 years old.
How could that be? You're 25 years of age. Did you have him when you were 8?
Younger than that, Your Honor.
Huh?
Younger than that, Your Honor, and then that would be trying to prove about physics and chemistry and biology. If you want to get that into anatomy.
May I suggest an evaluation, Judge?
I think I've heard enough here.
Yes, sir.
It's fine.
Good
day, Your Honor.
All right, John.
For me to be respectful.
We need a competency evaluation.
John, me and Mr. Hand have already talked about that.
Okay. Your answer. This is all collapsing on you because you're 25 and you're claiming your children are 17 and 18, which is naturally
17
possible.
on 18. Pardon me, Your Honor. Pardon my interruption. Have a good day. Good day.
And your statement, your answers are, well, really incoherent. What we're going to do is get a doctor to come in and talk to you and evaluate you. That's what we're going to do. That's the orders of the court.
November.
Dr. Edward Kahn will be ordered to review the defendant for competency. I think that's the right thing to do, especially we're going to. Okay, time out. Okay, we're going to try to help you here. Okay, Joshua, good luck. All right, the court will order Dr. Kahn to evaluate for competency.
Follow a motion or just go ahead and
follow it up, please. But I mean, I've
it's ordered. It's just a matter of need to put the paperwork to.
It's obvious.
Offices like to have those.
I'll prep the order and get the order sent over to you.
Yeah. Okay. What else, John?
I have another one on Terry Jackson who's just now been perfectly good confident, but he wants to be reinstated as probation revocation and a new case. So I would suggest doing a revocation hearing and
Terry Jackson. We'll just set it.
Just set it for a office hearing.
Okay.
Yeah, as soon as we can. All right.
What? Say that again.
He's confident enough to set it for a hearing on the motion of revocation.
All right. On Terry Jackson's cases, 1, 2, 3, 4, 5 cases, those will be set for motion to revoke probation hearing at the request of the defense.
Smart.
Okay.
Judge, I'm about to send you Miss Martin's case.
Okay. While we're waiting, I've got a Melissa Stacy.
That's a dismissal, Judge.
That's a motion to dismiss.
Martin, please raise your right hand. You swear or affirm have appeared before you and have
Case number 24CR2407, State of Texas versus Melissa Marie Stace or Stacy, STACE. A motion to dismiss. That case has been filed by the state and it is hereby granted.
Well, so she's got a misdemeanor possession.
Yeah.
Which will be on? Which will be on?
Thank you.
What is Texas?
Who is this?
This is Miss Martin, Stephanie, one of the 3 cases. She's pleading on the fraud and one of the thefts. One of the thefts has been dismissed.
Yes, Judge, you should have all the paperwork.
Stephanie Martin.
Dismissal.
It's a state jail, but it's in receive status, so I'll just use it. The possession.
So no resolution.
One.
It was created in March 18th. I'm sure where this one lapse.
They're not going to file that. This is felony possession.
3 cases are all the state of Texas versus Stephanie Rochelle Martin. Cause numbers 25-1071, and that is alleging a state jail felony of theft.
Both of the pleas are enhanced to a 3rd degree.
1072 will be dismissed as part of this agreement. That's a theft of property. And then 25 CR 1073 is fraudulent use or possession of identifying information. State jail felony with a bunch of tires. So that's that. Let's take these up in numerical sequence. We're beginning 25 CR 1071. In each of these cases, you are Stephanie Rochelle Martin.
Yes, sir.
Right here with Mr. Kimber, your attorney and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in some?
She does.
All right. In 1071, this alleges in paragraph 1 that on or about November 11th, 2024 in Jefferson County, Texas, you committed the state jail felony of theft. And it goes on to allege, among other, this is state. Okay. Indictment 1, paragraph 1 is theft of less than $2,500. To make it a state jail felony, there needs to be 2 or more prior convictions out of paragraph 2 of thefts. Correct, everybody?
Yes.
All right. And which ones are we alleging? Does it matter? Is it 1 and 2? Out of county,
multiple.
yeah, out of county courts,
Multiple misdemeanor.
law of 2 and 3. Paragraph 2 goes on to allege, ma'am, that on August 14th, 2001, out of County Court at Law 2 of Jefferson County, Texas, in 223744, you were convicted of the offense of theft. And the paragraph 2 goes on to allege that on March 15th, 2006, out of County Court at Law 3 of Jefferson County, in cause number 252495, you were convicted of another offense of theft. So paragraphs 1 and 2, if those 2 items are true, constitute a state jail felony. However, paragraphs 3, 4, and 5 allege that you were convicted of 2 or more state jail felonies of illegal possessions of a controlled substance in paragraphs 3 and 4. And I believe this becomes a state jail felony, though punished as though it were a 3rd degree felony by paragraphs 3 and 4. Am I right, everybody?
The 2 state jail convictions enhance the enhanced state jail.
So do you understand what you're charged with here?
Yes, sir.
This becomes a state jail felony, though punished as though it were a 3rd degree felony.
Right.
What starts out as a misdemeanor, it's published as a punished as a 3rd degree. It's a 2-step enhancement.
Well, at the end of the day, it's
3rd degree.
It's punishable as a 3rd degree.
Punishable as a 3rd. I don't think it doesn't function as a TDC.
No, hold on.
It doesn't function as a TDC.
This becomes, in paragraphs 1, 2, and 3, as we discussed, a state jail felony, though punished as though it were a 3rd degree felony. So it will be a state jail felony on the books, but it's punished as though it were a 3rd degree felony because of the prior felony state jail convictions that are alleged in paragraphs 3 and 4.
It's not a TDC conviction.
It's a state jail felony, but you're punished as though it were a third degree felony. So you're facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? And there is an agreement that's further been reached where you would be sentenced to 5 years in prison. I think that's a 5, isn't it? Is that a 5 or 6?
That's a
5.
That looks, yeah. We gotta fix that. Everybody right, we're writing fast here and these numbers sometimes.
It's 5.
I wrote the Arabic 5.
Thank you. I wrote that thing on for
This agreement is that you would be sentenced to 5 years in prison to run concurrently with the second case you're going to be pleading guilty to, and a third case will be dismissed.
Yes, sir.
Is this your understanding of the plan?
Yes, sir.
And also, Your Honor, states agreed not to file a pending state jail possession case.
Yes, Judge.
If I follow, okay, yeah. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
You got this in.
Yeah, I think of the admonishment, I just marked the third degree.
So how do you plead to August 24th, 2015 in this criminal district court of Jefferson County, Texas? You were convicted in cause number 1523034 of the state jail felony of possession of a controlled substance. Is that true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
And the next paragraph 4 goes on to state that you were also finally convicted on April 11th, 2016 of illegal possession of a controlled substance, a state jail felony in this criminal district court of Jefferson County, Texas, in cause number 15-23446. Is that true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
This constitutes then paragraphs 1 and the 2 portions of paragraph 2 of prior convictions that you're pleading true to, and paragraphs 3 and 4 of this indictment constitute a state jail felony, though punished as though it were a third degree felony. And again, you're facing not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
And the agreement again is reached that you would be pleading guilty, sentenced to 5 years in prison to run concurrently with this next case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So finally, how do you plead to paragraph 1 of this indictment charging you with theft, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Just to be clear, Your Honor, she's currently serving out a 7-year sentence in plain state. That's our intent that this run concurrently with the case she's already serving a 7-year sentence in as well.
And in paragraph 2, these prior convictions out of county courts of law that you pleaded true to, are you pleading true voluntarily and because those are true as they are alleged.
Yes, sir.
And finally, paragraphs 3 and 4, those prior convictions in this criminal district court of state jail felonies of illegal possession of controlled substances, are those true and correct as they are alleged? And are you pleading true and correct to that voluntarily and because those are true?
Yes.
I find, if nothing further, that the defendant has entered pleas of guilty and true respectively to paragraphs 1, 2, 3, and 4, which constitute a state jail felony punished as though it were a third-degree felony. She is mentally competent to do so. She understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting the guilty pleas and pleas of true to find her guilty of this state jail felony punished as a third-degree felony. And I find her guilty beyond a reasonable doubt of this state jail felony, punished as a third-degree felony. I'm following this agreement. The defendant is hereby sentenced to confinement for a period of 5 years based upon the agreement of this state jail felony, punished though as though it were a third-degree felony for the enhancements. So do you understand what has happened on this case, ma'am?
Yes, sir.